Hey, Brian Parker here, standing at the Red Wings wall. I just did a long video on how to beat a Bank of America lawsuit, and I incorrectly cited Al Sabatka as the limo driver. You can see in the video, he was the Zamboni driver. Anybody that knows the Red Wings know what I'm talking about. This is from the 1997 Stanley Cup champion winners. They all signed it. At least that's what my former brother-in-law told me when he gave this to me. So it could be worth a lot of money or not worth anything. But your lawsuit, the lawsuit against you from Bank of America, could be worth a lot of money to them or nothing. And I'm going to show you how to make it into a zero, hopefully, as big as a puck. So this video we did just a little while ago. You can go on killdebt.com and find the long video. This is a quick synopsis of it. I'm going to include with the long video on killdebt.com a BOA survival package, how to give you all the documents, the answer, the counter affidavit, the affirmative defenses, my special letters for you to attack the lawsuit before and after you are subject to it, because you may just get a collection letter first, and that gives you a hint and a half that the lawsuit's coming. My letters will counteract that and set you up nicely if they do sue you, and it may stop them. It'll also help you settle a case once they either sue you or they're on the verge of doing that and you want to work with them. And there's ways to do that too. But the video I'm going to show you, it was a 5-part attack plan, Shazam. And in the long video I just did, I'm going to show you paragraph by paragraph. Here's their number 1 paragraph. Here's our response. There's a number 2 paragraph. Here's our response. So that'll be your answer. You'll see the affirmative defenses, which I will incorporate inside those issues and things about the securitization and the pooling and servicing agreement that are part of your defense in the long video. We'll review arbitration. I don't like arbitration. It's too arbitrary, but there are pro tips in my long video that show you how you can successfully do arbitration in certain places and the ways that maybe you want to consider, I say, to do it. You're going to be blitzing them or threatening discovery of the securitization documents. That's a part of any creditor case. So while this is against Bank of America, it's also against every creditor. You can use these skills in the long video I just did to go against any creditor. And I'm going to show you how to strike the pleadings down and push for summary judgment or a walkaway to get your hockey puck, to get your zero. So again, Shazam, you'll see affirmative defenses and an answer. I'm going to allege that plaintiff sold the receivables to the BA Master Credit Card Trust. Delaware governs. That means it's a 3-year statute of limitations. You haven't paid in 3.5 years, you're out in Z. Be aware of the arbitration aspect of it unless you can come to your own terms. Pro tips how to do that. Cite missing documents. In the lawsuit that we're going to look at, let's put it up, Shazam, 2 pages. That's it. There was no proof. They cite agreements, they sign debt amounts, but there's nothing backing. So we cite that for the court in our counter affidavit. That'll be part of your Bank of America strike package attached to this long video on killdebt.com. And again, you'll attach your counter affidavit that I'll show you how to create. We will also do the following in the longer video, Shazam. We'll have an analysis of how to create a preliminary statement, how we do word for word, paragraph by paragraph, the pleadings against, they're called responsive pleadings. So when you file an answer, that's an answer, but it's really, you refer to them as your responsive pleadings. You're responding. It has a more meaty sound to it. It sounds like you know what you're doing. Anybody can answer anything, but responsive pleadings show that you know what you're talking about. So affirmative defenses show that you do not want to waive anything. When you do affirmative defenses, bring it or lose it. You snooze and you lose. So while you will not bring boilerplate nonsense, you will bring things that you know in good faith can be shown later on, and you've done the research to know that this affirmative defenses belongs against the Bank of America or any creditor lawsuit. And then again, I'll attach the counter affidavit showing you how to use that against Bank of America. A couple of things I want you to remember, all right? Shazam. There's a standing gap. BOF has to prove trustee authority, not just we own it. And by the way, in their lawsuit, you'll see they own the account as opposed to the debt. What happened to the debt? There's at least 2 owners now. So who has standing to bring for either owner? The real party in interest. I cite up there my law in Michigan, but there's real party in interest statute, court rules in your state. Just look for them, very simple. So you've got to show that they either repurchased the thing back from the trust, the account, the debt. None of that happened, and there's no proof of it. And conditions precedent, meaning the PSA, the pooling and service agreement, has specific rules for Bank of America that's given it to a trust to obtain it back. Those rules, you've got to show that those rules were followed. You don't, but you allege that they didn't, and now they've got to do all the work. That case will get settled. So we want to also give you in the long video I just did, and this has become a long video, a pro tip. Everything I do for you to use, whether you want to or not, it's your law, your life, is towards settling. The more information and bargaining chips you have, the more you're going to settle that debt either to a hockey puck or somewhere close to that. So if you decide that you're going to ignore my advice, and that is your American right, I'm just going to go use a service that says admit, admit, deny, deny. Why is anybody going to settle with you? Now, if you use a Parker approach and be a Parker problem, you will have all these bargaining chips that the debt collector does not want to get into and spend his client's money. So that gets you where you need to be. And that's the purpose of what I do, to give you bargaining chips. And you can be your own mini attorney for you. He's got 160 cases. He doesn't know what's going on in any of them. But if he knows what's going on in yours, that's the last thing he wants. He just wants to go home at 5 o'clock. So use those bargaining chips that I give you in the long video, and you will be able to strike back at Bank of America. Again, go to killdebt.com, look at all our forms. Let me just give you briefly the form vault. That's that information. Click, click, click. Also, Kill Debt AI is coming. We will have an AI setup where you can take the nuttiness that is my brain and put it into your pleadings. Not just admit, deny. It'll be all this stuff that I give you from the forms vault into an AI mechanism that's coming June 2025. I hope you'll join us. I hope you'll go look at the long video that's on killdebt.com. And I hope I gave you a couple of hints to help you today. Thank you.